Welcome to the SNF Spotlight series. I'm your host, Yitz Rubin, and in this series, we will be speaking to some of the healthcare leaders who are making a big impact in the industry. Join us as we shed light on a variety of topics that will benefit both our SNF colleagues as well as the general public. Dana, thank you so much for joining us on the SNF Spotlight.
I'm delighted to be here.
So she is a partner at Stris and Maher. You litigate complex healthcare, pension, and other commercial disputes in trial and in appellate courts throughout the country. You have recently litigated 4 healthcare and pension cases in the U.S. Supreme Court alone, and has crafted firm strategy in many high-stakes disputes between healthcare providers and insurance companies. So Dana, welcome, and tell me a little bit about you and your upbringing.
My upbringing. So I'm from New Jersey. I always wanted to be a lawyer because I was liking to fight my parents and my brother when I was a kid. So it was no surprise that I chose this path. Yeah, I've always known that this was for me, and I think it has proven to be the right choice for me.
Yeah, there's definitely nothing like a good family argument.
Amazingly, I am the first lawyer in my family. My parents are professional card players. They're professional bridge players. And that's what my brother does and what my husband does. So everyone else is kind of getting the better of games, playing games in that kind of setting. And I'm the only one who does it in the law.
Oh, wow. So what made you choose a career in law?
Winning fights is definitely the funnest thing in the world. And I knew from the time that I was maybe 8 or 9 that I wasn't going to be the best card player in my family. So this seemed like the good backup option.
What is a professional bridge player? What do they do? How do they make money?
So it's a strange community. There are about 150,000 members of the Bridge League in the United States. And the way that the professionals make money is by playing on the top teams. So it's sort of like some of these very wealthy gentlemen, they hire the Yankees and then they play first base. That's how bridge players make money.
Oh, cool. So why do you choose in regards to law to apply your skill sets toward the healthcare industry?
Sure. So my law firm, Stris and Maher, is very well known in the ERISA space in particular. And I know ERISA is a strange word. It's a federal statute that was enacted 50 years ago that protects employees in various contexts. So my law firm has always been an ERISA firm. It's very prominent before the United States Supreme Court, especially litigating these complex ERISA cases, especially over the past, I would say, 20 years. We've been doing dozens of these ERISA cases in the appellate courts and before the United States Supreme Court. So when I joined the firm, I started doing that, and that was really exciting. And then I had the chance to start representing some healthcare providers directly, getting to know their business, handling their ERISA problems, sure, but also handling other problems that come up for healthcare providers, insurance disputes, licensure problems, you name it.
So can you, for the basic folk, for like myself who doesn't understand law very well, can you describe ERISA law and how that affects the healthcare industry and the SNF industry in particular?
Yeah, absolutely. So ERISA is a federal law that was designed to protect employees who get benefits from their jobs. So what kind of benefits are we talking about? Typically pension benefits, so retirement benefits, or healthcare benefits. And as you know, most Americans get their health insurance from their job. So that means that ERISA is the law that governs, that applies to almost all health plans that people have in this country. So it really affects tens, hundreds of millions of Americans all the time. That's one reason that it's so exciting to be an ERISA lawyer. You think it might sound funny, but it's actually true. We do like what we do because it affects so much money and so many people. And ERISA, just kind of broadly speaking, it does a few things, but 3 things in particular that healthcare providers should be aware of. First, it provides some procedural protections. These are the things that you're probably familiar with. you have to tell people what's in the plan. You have to tell them if you're denying their claim, why you're denying their claim, and give them a chance to appeal. The second thing it does is really important, and it makes employers a fiduciary when they're dealing with employee benefits. So what do I mean by that? So normally when we're dealing with our employers, it's kind of we're each acting in our own interests, trying to get the better of the other one. I want a raise, you don't want to give me a raise. But in the ERISA context, when we're dealing with health benefits, you, my employer, have to act in my best interest. So if I need heart surgery, you can't take the money for my heart surgery and go to Vegas. That's not allowed. So that's another really important thing that ERISA does. And the third thing is kind of become more of a thing recently. It requires ERISA plans to cover certain kinds of medical treatment. So for example, if you are an ERISA plan and you provide mental health benefits, so people can go and get therapy if they need it, you can't provide them in a way that's very stingy compared to the other kinds of benefits that you offer. So you can't say, oh, Yitz, if Yitz needs 10 heart surgeries, no problem, he can have all those heart surgeries. But if Yitz needs more than 5 mental health therapy sessions, he's out of luck. 5 is the maximum. ERISA says that you can't do that. So those are some of the main protections that apply and that will be relevant to different kinds of healthcare providers as they interact in this space.
So ERISA is like a global, not a global, a national, in the entire US law protecting benefits to be able to, it's the law governing what someone has to give, what benefits employers have to give. Is that a general way of saying that?
Exactly. And it's the one, so if you're a healthcare provider and you don't get paid for the service that you rendered and you want to blame someone, typically your fight is going to be covered by ERISA, because ERISA is the thing that might require that health insurance company to pay you in the first place.
So on which side are you typically on, or your firm, Stris and Maher? Are you typically helping the healthcare providers or the employers, or are you on the employee side?
So there's actually 2 different sides here, and they're not what you think. So the sides are the healthcare providers, who are typically on the same side as the employees, people who want the benefits, who want the services. And on the other side, we have health insurance companies. So Cigna, Aetna, Anthem, all the big ones that you've heard of, those are the people that we don't represent. And those are the companies that are typically represented by the biggest, fanciest law firms in this country. So if you've heard of a law firm, they probably represent the insurance company. We are a firm that's unique in being able to handle very difficult, high-level cases, but we almost only do it for the little guy, the side of the medical provider or the beneficiary in the plan.
I mean, you say the little guy, but some of these groups could be extremely large, these SNF owners and operators. So you would represent those SNF owners and operators, which are on the same team as the employees, going against the insurance companies to make sure that they get the benefits that the ERISA law governs.
Absolutely. 2 things on that front. So the little guy is obviously context dependent. One of our clients was DaVita, which you might be familiar with, is a very large chain of dialysis providers. So they're only little compared to Cigna or something.
I mean, I want to know a little bit more about ERISA law and how, in particular, this affects the SNFs, the SNFs in general.
So one thing that's really important about ERISA is to have the best chance as a provider, any kind of provider, of being able to effectively argue under ERISA in court. So to go bring your lawsuit, try to get paid. That's the most common kind of lawsuit, right? Trying to get paid. To have the best chance of doing that, you need to prepare in advance. So your best chance of getting paid later is if you do the work now, invest in a good lawyer, make sure that all of your paperwork is what it should be, that you're getting something called an assignment of benefits that would be valid in an ERISA lawsuit, that you're doing other sorts of paperwork and data collection to make sure that when you go into court, you are going to have a claim. Because one thing that happens to many, many healthcare providers in any space is you're not paid, the unpaid balance grows. And now you say, okay, somebody has breached a contract, right? I'm entitled to be paid for this service that, after all, I got pre-authorized. Someone told me that I could provide this service, and now they're not paying. Then you go to court, and the court says, oh, I'm sorry, you're not the right person to bring this claim. It should be the patient, or it should be somebody else. And there's nothing you can do now. You don't have an ERISA claim. The court has closed its doors to you. And you don't have a claim under other state law because all of that is brushed away by ERISA. ERISA has what is called preemptive effect, which means that anything that kind of comes close to ERISA is preempted, is made no longer valid, and ERISA replaces it. So often what happens is healthcare providers don't have the right documents, or they've been accepting the wrong kinds of plans. And now they don't have an ERISA remedy, and they don't have any other remedy available to them under state law. So that's the kind of service. I mean, how can people think about ERISA and take appropriate action to protect themselves? Got to talk to a lawyer, got to have somebody look at your especially your admissions paperwork and all of your paperwork where you collect that assignment of benefits that says, oh, somebody should pay me if any insurance benefits are payable to me. That's very common language. That's no good under ERISA. You need a much more specific and expansive assignment to make sure you have those rights so that you can go get the payment that you've earned in court.
So you're saying that before anyone signs with insurance companies, that they have to make sure that this insurance claims and benefits are all they're under ERISA or they're not included in ERISA, because if something's in between, so then they would sort of get lost and be somewhere in the middle.
Before you take a patient, before anybody accepts a new patient, that's what you would definitely want to make sure you understand their benefits and where their benefits are coming from. I'm sure that you have people who accept Medicare and Medicaid, but you might have some facilities that don't accept Medicare and Medicaid. It's very important to know what kind of benefits you're dealing with before you accept that patient population into your center. So that's going to be true across the industry, and it's certainly true here. For providers who want to contract with insurance companies, you want to go in network and get that kind of treatment. Also, there are ERISA implications there. So that's definitely something you want to think through.
So this is something that your firm and you help with them getting into network, or at least the precautions and making sure when they get into network, they're doing it in the best possible way for themselves, as well as if something goes wrong after, you'd also come in and litigate on their behalf.
Yeah, so I don't know if this is an issue you've heard of a lot, but often when a provider gets too big or successful, an insurance company will start an audit. So they'll either do a prepayment audit and stop payment altogether while they're looking at your records and taking forever, or they'll do a post-payment audit. They'll ask for your records going back many years, trying to find reasons to ask for your money back. Those are situations where it can get really expensive, and it definitely makes sense to have legal advice. For example, if they're asking for really old records, maybe they're not entitled to those records because maybe whatever you did 5 years ago, it's too old for them to recover their payments. So maybe you can kind of lop off that concern and narrow the scope of the inquiry. All sorts of things that can come up that a lawyer can kind of help you navigate.
So can you tell us about some of the violations you have come across?
Sure, that's fun.
Besides for family feuds, we're talking more.
So ERISA violations, if you ever just feel like you're not getting enough email and you want to get some more, just type ERISA lawsuit into your Google alerts and you'll just get dozens of emails a day about different kinds of ERISA things that have gone wrong. Let's see, what are the best ones? The most common ones are people who haven't gotten paid for treatment that they need. That can be really, really sad, especially if the person has a life-threatening. I have a pro bono client right now who has a life-threatening medical condition that his insurance company knows about and keeps kind of playing coy about whether they're going to cover it or not. So that can be very frustrating. But there are some funny things that happen under ERISA all the time. Typically, the funniest things that happen are when employers breach their fiduciary duties. So we talked earlier about how the employer is supposed to act in the best interests of plan participants, right? They're supposed to give you the benefits that you're entitled to. When they make decisions, they're not supposed to be thinking, how can I save money? They're supposed to be thinking, how can I provide the benefits that I have promised to my employee? But you see a lot of stuff where we need a vendor to take care of the bookkeeping for our plan. Oh, I'm gonna hire my brother. Oh, he charges 200% more than the next closest competitor. Who cares? It's the plan's money. So that kind of self-dealing, breach of loyalty, where people are doing stuff that benefits themselves but doesn't benefit the plan, that kind of happens all the time, and it can get pretty extreme depending on the situation. It's more extreme, I would say, in the pension context, where there's so, billions of dollars at stake, billions of dollars being managed by hedge funds and by money managers, and the fees that they can charge can be really exorbitant. So those are some of the most, I would say, outrageous cases that I've seen most recently, but anything is possible.
So what are some of the most difficult disputes that you recently worked on?
I have a client, I think he would like his story to become more well-known because it's really sad. So he is very ill. He's been very ill for almost a decade now. And he's had the same insurance company the whole time. Starting in 2018, they just stopped paying for his treatments that they knew he needed. He needs a lot of treatments. He goes for treatments every day for 7 or 8 hours a day. So it's very intense. And he needs these treatments to stay alive or his organs fail. So this insurance company started denying coverage for these services. And my client sued and said, hey, start covering me. And also you're breaching your fiduciary duties to me because I have an ERISA plan and you have fiduciary duties to me. The really frustrating part of that case is that because of some special rules in the court where we've been litigating, his breach of fiduciary duty claim was dismissed from the lawsuit, so he no longer has it. And all we have is a claim for the benefits that he was supposed to get all along, which obviously it's too late now. He needed that treatment 3 years ago and he didn't get it. And also, the insurance company isn't worse off. Even if we win everything that we're asking for, the insurance company isn't any worse off than if it had just paid in the first instance like it was supposed to. Normally in the law, we try to make incentives for people to behave well, to be good fiduciaries, to honor their obligations under contracts. Here, they didn't do what they were supposed to do. My client got much, much sicker as a result. And all that he's entitled to is the money that they were supposed to pay him 3 years ago for these treatments. I think that's been really frustrating for him and for me as we navigate this case.
Right. I mean, that sounds like a serious issue because when people's health is concerned, it's not like someone could wait in court for 5 years to wait till they get that heart transplant or kidney transplant. It's something that needs to be done quickly. So how does that work? Is there can one sue for that? That if it was delayed due to the insurance companies not paying?
Absolutely. So you can sue and say, I need this heart treatment now. If I don't have it, I'm going to die. But the way that the process is written under ERISA, you have to first ask your insurance company a few times. You have to make sure that they've really said no before you can go to court, and then you have to go to court. So it can take a little while to just go through the process. I'm talking, weeks, which could be the difference between life and death for some people. And then it used to be that if somebody denied your claim and they didn't have a good reason for it, they denied your claim, but they knew that you needed that heart surgery, and then you died, you could sue them and get compensated. Your family could get compensated for the loss of you as a person. Under ERISA, that's not available. You can't get what are called consequential damages, the damages that result from somebody's failure to do something that they were supposed to do under ERISA. So it's kind of ironic because the statute that was meant to protect people, to protect employees who have health insurance from their jobs, it has turned into something that makes it really hard sometimes to recover and makes it seem really unfair that people can't get money that they should from insurance companies.
Would you say that this actually, for example, if let's say residents within a skilled nursing facility or a group, are they covered under the group? Is the group covering not just their employees, which is their nurses and staff and things like that, but also their residents?
So there could be different ways that the residents have healthcare coverage. It could be from ERISA because they are an employee or a spouse of an employee in a company. It could be from Medicare or Medicaid. It could be from Obamacare. So all of these different ways that people have covered, it would be unique, as far as I know, to that person. So that person and probably their family members might have coverage the same way. But you could have in a single SNF, in a single skilled nursing facility, you could have people who are covered by 10 different kinds of insurance, but of course, people who are not insured. So it becomes very hard, and it's a big administrative burden to figure out how are you supposed to meet the requirements of all of these different insurance companies, all of these different schemes, and also, of course, like, does this person even have this benefit in their plan? So it adds a lot of complexity for SNFs and for facilities in general.
Right. So you're saying ERISA doesn't cover, it's not covered through Medicare or Medicaid. It has nothing to do with that. ERISA care has to do with the just employees, and just employees, covering employees within an organization. And sometimes those employees would ending up into a SNF. So
Yep.
the ERISA care would be paying that, but it's not a common occurrence that a SNF would be getting reimbursed under the ERISA care as far as on the resident side.
So two things. It could be, anytime an insurance company, anytime a SNF is taking private insurance, it rates to be ERISA because it rates to be under that rubric. But the second thing is, if you're a SNF and you're providing benefits for your own employees, you are providing an ERISA plan. It's a funny thing for me because I am a partner at my law firm that handles ERISA issues on behalf of employees, but I am also a trustee in our ERISA plan. So from that side of the situation, as an employer, you also kind of need to know what's happening with your employees, making sure that they're getting the benefits that they're entitled to, because actually you are responsible for that. And you are a fiduciary for your own employees, your own technicians and nurses and the folks who work at your facility.
Speaking with the owners and operators of SNFs, what would you say the number one issue or law that they should know about ERISA?
I think that the most important thing that they need to know is about the paperwork at the beginning, to make sure that they're getting themselves effective admissions paperwork from all of their residents that makes them in a good position to fight an insurance company if you need to. This is, in my own experience as a person who goes to doctors, extremely rare that healthcare providers have good paperwork. And you can find someone, I do this, but lots of people do this. They can take a look at your paperwork, making sure that it's good, so that it's such a low level thing. It's such an easy thing. It's not going to cost you any money. And it's going to maybe put you in a position where, God forbid, you have a big fight with an insurance company, you might be able to get that money back, as opposed to having the courts slam their doors in your face.
In your opinion, what changes need to be made to the industry to improve the SNF space?
I have not yet had the honor of working with any SNFs, so this is a new area. So most of my clients are behavioral healthcare providers, typically mid-sized chains of behavioral healthcare providers. So in that space, I can kind of speak with authority. Here, I can just kind of give my general impressions about the issues facing providers of this kind of service. I would say, from my perspective, again, my perspective is limited because I come in when people are having really, really big fights. So from my perspective, something that I'd really like to see changed is the administrative burden on providers to get paid. I think that so much of all that we spend on healthcare kind of winds up with your billing coordinator, maybe your revenue cycle management specialist, all of the people that you employ to send bills to Medicare and Medicaid, to private insurers, to make sure that you're complying with their billing guidelines, whatever they are. And who is this helping? So I don't know specifically how it works, how it interacts in the skilled nursing space, but I would say it's a pattern that I've seen across industries where there's 7 million requirements. You have to pay all these people to get it right. If you don't do it right, you don't get paid. And even when you do it right and you do get paid, it's often on a lag, and then maybe you're going to get audited years later, and there may be a dispute. So it would really be just great, although not for my business, but great in general, if we could cut back on all of that paperwork and all of that administrative apparatus that needs to be in place to get our providers paid.
So Dana, how can people connect with you? I mean, you've got a ton of experience, partner at Stris and Maher. How do people get in touch?
Absolutely. So I'm on the socials, Facebook, Twitter, Instagram. The firm has a Twitter account and a Facebook account. I'm also on LinkedIn. My name is Dana Berkowitz. I'm around, find me, say hi. I'd really love to hear about the issues that you're facing. If any of them overlap with the things that we've talked about today, great. If they don't, awesome. I like learning new things. So I'd really love to hear from all of you.
Dana, thank you so much for being a part of the SNF Spotlight series and teaching us about ERISA problems. You're doing an amazing work, and we look forward to following you in the future.
Thanks so much for having me, and good luck with everything.
The SNF Spotlight series would like to thank the Renewal Rehab family for sponsoring this program. Renewal Rehab is the best therapy provider for SNFs nationwide. So if you're an owner or an operator of a skilled nursing facility and you want contract therapy, you are going to want to call and connect with Renewal Rehab. This series is geared towards highlighting healthcare leaders as well as healthcare heroes in the SNF space. So thank you all for watching and supporting this program.